Hi, I'm Gary Schuster, and welcome to my podcast. This is episode one of Innovation Cafe. And a little bit of background about me. I am a licensed attorney, went to Harvard Law School. Um, you'd think that I'd be practicing law full time, but I found that inventing is a lot more fun. So I'm sitting at around 250 issued United States patents and a bunch more applications. And it's time that I give back. So I want to share with you the tips, the tricks, the methods you can use to turn your creativity, which you all have, into something that is fun, like a hobby, coming up with new things, but also something you can make a living off of. And so today's presentation is what is intellectual property and how you turn invention into investment. Now, this is not the most fun portion of inventing. Of course, the most fun portion is that 1 minute that you come up with the amazing idea, and then maybe the couple of hours while you reduce it to something that actually has practical uses. And then there are hours and hours and hours trying to monetize it. So this is a little bit more about the hours and hours and hours than the fun part. But if you're following my advice, you're going to find that when you innovate, 99% of the value of what you do comes from about 1% of the time, which means that you should be failing a lot. You should come up with so many things that don't work that you lose count, because you only need that one thing that works, and you can throw out the other ones. So, of course, you may come up with more than one thing that works, or more than 250 things that work, and that's great. So, let's turn to today's topic. What is intellectual property? Now, I often would present to school kids on what intellectual property is, and it's just really, really a simple thing. Point to someone, one of the kids, and say, "Well, if I take your shoes, do you still have shoes?" And the kid will normally look around and say, "Yeah, of course, you have my shoes. I don't have shoes." And then I'll say, "Okay, but I took this picture on my phone. Now, if I send you a copy, do I still have a copy?" "Well, yeah, you do." Well, intellectual property is a set of rules that the government creates that allows you to control who makes money off of your ideas and what happens with your ideas. And, in some cases, it's literary ideas, and that's copyright. In some cases, it's secrets, like the formula for Coca Cola, and that's a trade secret. In others, it's patents, and that you actually have to go beyond an idea and actually reduce it to something that works, an actual invention. So let's see what's next. Let's start at the end. And no one really likes to start at the end, but you got to, okay? The first question you have to ask when you're trying to make a living with your brain is, how do I get out? What kind of exit do I want? Do I want to exit this super wealthy? Do I want to exit this with a job at a big division of a big company? Do I want to start my own company? Do I want to be the next Facebook, or do I want to be the next acquisition by Google? Or do I want to just license it out? And if you're a really prolific inventor, you'll find that licensing it out may be the only way to go. Um, I'll do a whole episode on the prolific inventor problem, or the high speed innovation problem. But if you have one invention in your life, you're going to ride or die with that invention. You will run it into the ground to success or failure. If you have one invention every several years, you're going to partner with people to build them out. You'll probably still build them out yourself. If you have an amazing invention every week or even every month, there is not a chance that you are going to develop all of these into working functional prototypes or companies. So what do you do? Well, you get into a situation where you have a lot of partners you work with. Sometimes you simply explain to the public, which is what a patent is. It's an explanation how you do the thing, and you try to find someone else to do it. And so there are a few different exit strategies, and a lot of them will depend on what you want in your life, and of course on what it is that you've come up with. Um, so you also should be planning for everything that you might reasonably expect to happen. So if you're thinking that might be going to want to sell to Google, maybe, well, you might want to consider what programming languages Google uses if your innovation is, say, a new piece of software. Um, you want to program it in a language that their engineers will look at and go, oh yeah, we'd love to acquire this. Um, what IP do you need to execute on the strategy? And that's a really good question. Um, and again, subject for another episode, but US patent law in the US is a huge, more than a quarter percentage of global gross domestic product. And so, 25% of the world's economy is just the US. The US patent law matters a lot. And it is also known as a rule of law country. So, you can go to court and actually enforce your rights. And US patent law has become very unpredictable. Even patent examiners don't know what is patentable subject matter anymore. So you might want to just keep it a secret, and that's called a trade secret. And you do that if you have a process that you could run, say, on a server that's running in secret in your basement, and you get data in and you return data out. And if that's a workable business plan, great. You don't need to spend a penny on lawyers. Well, maybe spend a little bit to get a proper non-disclosure agreement and things like that. If your idea is, hey, here's a product that everyone's going to want in their pocket, well, you're going to need a patent on that. If your idea is a book, you're going to need to file a copyright and probably want to register with the Writers Guild of America too, just for good measure. There are a lot of different approaches. If it's an ornamental design of something, that's a design patent. There are a bunch of different kinds of intellectual property, but we're going to go over the main ones. And you got to plan for your backup strategy. So how are you going to monetize your IP if your venture fails? And it's actually been the source of a lot of heartburn in the tech industry, because when a company goes under, it's not uncommon that their patents get sold through the bankruptcy. And they often are sold to so-called patent enforcement entities who will go out and enforce the patent and make money even though they're not producing a product. And it makes sense. It repays the lenders who loaned to the company that developed the technology. I mean, there are a lot of reasons why it happens, but yeah, it can be a really nice parachute if the airplane that your invention is traveling in were to crash. So the strategic thinking is, how do I exit with what I want? And of course, this woman in the picture is exiting with a big pile of money, which is kind of funny. But you really think backwards, and there's no need to go down pathways that don't take you towards an exit that you would be interested in making. So, what IP do you need? Well, there's copyright, there's patents, there's trademarks, there's trade secrets. Trademarks are they'll get their own show too, but they are designed to prevent consumers from being confused as to what company something's coming from. And of course, your backup strategy. So now this is sort of the boring part. IP soup. What is it? And you can see there are a ton of different endpoints here for intellectual property. And let's just start with some of the bigger ones. First is marketing, names, things like that. These things are important, obviously, but they're not what you would consider to be a really traditional type of intellectual property. More importantly, they really are trademarks, which again, not what we think of as intellectual property, but it is. It's a form of intellectual property. So a trademark is something that we do, that we create legally to prevent consumers from getting confused. If you were to go to the supermarket and you saw Microsoft Cola sitting in the cola aisle, you'd probably, even though it's a cola, think that this stuff came from Microsoft. Same thing with Google. I mean, if you saw a magazine called Google Monthly, you would think that that's probably coming from Google, or at least about Google, the company. So trademarks help prevent consumers from being confused. Now, that said, they make a lot of money for trademark holders. In fact, if you were to ask me what IP would you rather have, the trademark Coca-Cola or name a patent, well, with the exception of some medical patents, the trademarks are probably more valuable. So let's go over to the ideas side over here. And ideas are, of course, where I love to live. The first one is we'll hit up is ornamental designs, right? The interesting thing about ornamental designs is that they are both capable of being a trademark. Your ornamental design might be your trademark. It might you can get a trade dress trademark. You can get a design patent on the ornamental design, and in some cases you can copyright it. So it kind of has all the different possibilities. Now moving over to written expressions. Once you've recorded your thoughts in a tangible medium, they are automatically copyright. You don't have to do what used to be called the poor person's copyright, where you stick it in an envelope and seal it and get it postmarked. None of these myths are things that you need to worry about. Instead, just stick with what you're going to stick with here, which is file the copyright with the Copyright Office, get it registered. But even if you don't, the copyright exists in the United States the moment that you put it down in a tangible medium. So your written expression definitely is copyright. I mean, you don't need a lawyer, you don't need anything to cause a copyright to arise. Now, if you're using someone else's copyrighted works, you probably would be well advised to talk to a lawyer, because you have to fit under fair use or get a license or whatever it is. And that makes that makes music, for example, where you include sampling of other people's copyrighted works, a very complicated thing to do. So now let's look over here at utility patents. And utility patents are actually quite important. What a utility patent is what you think of when you think of a patent. It's the patent on the light bulb. It's the patent on the internal combustion engine. This is, there's something like 11 million issued US patents, and there's patents throughout the world. Those are the ones that they don't last very long. Like a copyright lasts until well after you're dead. Unless you're a child, no work created during your lifetime is ever going to be free for you to use in the US because of how long the copyrights last. So as a practical matter, copyrights are permanent for the sake of any individual living human. They do expire eventually. Utility patents tend to last 20 years from the date that you first filed for them. They have to be useful. They can't be obvious. They have to be novel, meaning that no one's done the exact same thing before. And they have to fall under what's called patentable subject matter, and that will get numerous episodes on this podcast because it's a really complex thing. So turning to the next, we can see how they interrelate. Okay, I should have mentioned that there were trade secrets in there that my picture was sitting on top of, but trade secrets are just that. It's something you keep secret and you sue over if someone leaks it. But if they come up with it on their own, you're on your own. So you can see the overlap here. There are things that are trade secrets, there are things that are copyrights, there are things that are patents, there are things that can be a trade secret until the patent publishes, and you can actually make a non-publication request in the United States, and if you file only in the US, you can hold it as a trade secret until the patent issues, and if the patent never issues, the patent never publishes, and it remains a trade secret. And that's why, even though patent applications are supposed to teach exactly how to do the invention, it can be simultaneously a patent you're looking to get and a trade secret. And of course, copyright. And when you think of software types of patents, There's going to be copyright to the code, but there may also be function within the code that is subject to a patent. And then this greater circle that you see on the outside, the white circle, well, that's innovation in general. And a lot of things like democracy is an amazing innovation, but no one's going to get a patent on it. There are plenty of things that are very innovative that are not patentable, and it's a hard lesson. You can't protect some of your inventions, but it simply is. Because remember, it's that same thing. If I take a picture on my phone and I send a copy to you, you have one and I have one. We both still have the picture. So, and then trademarks, of course, way out in its own little circle because they're not really protecting your creative output. They're protecting the consumer from being confused about where your stuff comes from. So now let's look at where we care about intellectual property. Um, if you look at this chart, you can see that the U.S. is a huge portion of it. It's the biggest chunk by far. Um, China, also a big portion of it. Um, Chinese intellectual property protection is a little bit complicated. I know that they have a reputation of not being that great on intellectual property, but actually they're getting much better in recent years. And if you have a really valuable invention, there's a good chance that the product implementing it will be made in China, and a Chinese patent wouldn't be the world's worst idea. So let's say you have an invention for a much better cat toy. So now you're going to look at two things. You're going to look at the big markets, the USA and China, because, well, obviously they're huge. You don't need that many pet owners there to make a lot of money. And then you're going to look for countries where there are a lot of cats. So you'll literally be Googling what countries have the greatest number of cats per capita. And those are countries you probably want to file in. So at minimum, if you want to save money, the way to do it is you file a provisional patent application. That will also have its own show. And you then file what's called a PCT, a Patent Cooperation Treaty application, which can give rise to patents throughout the world. You have to enter into a national phase and do a special filing, but they can. So the US plus China plus Japan plus Germany plus the UK, you're well over half of the global gross domestic product. Now remember, IP is really, really territorial. So your US patent does not mean a thing in France or Germany, and your Mexican patent doesn't impact your business in Canada. You have to infringe it in the country that you have the patent in. And the same thing is true of copyrights, but that's different because most places the copyright will rise on its own without having to go through a process of applications. So let's take a closer look at trademarks and why do you care? And this is maybe my favorite case because it's so stupid, but fun. North Face versus South Butt. Someone literally came up with, and you can see the logo here, a clothing line called the South Butt. And they were sued for trademark infringement by the North Face. And you can see the little R in a circle next to where it says face in the North Face logo, and that is what you look for trademark. So you look for the circled R, and that means it's a registered trademark. You'll notice how there's no R here. They never, as far as I know, got the trademark registered. But you can easily see how a consumer could get confused. There's the North Face and the South Butt, and you could think, well, maybe the North Face has a farcical line of clothing, and so that's what the case was about. And like all these cases, the cases that we pull up as examples are usually pulled up because they're edge cases, so it doesn't actually matter how well. It matters a lot to them how it came out, but for our purposes, what matters is even a case like this where one is clearly mocking the other could end up with some trademark litigation going on. So copyrights again locks it up forever as a practical matter. I mean, unless you're planning on living 95 years after publication for a corporate work, or living past the life of the author and 70 years after that, it's not going to happen. So The Spy Who Came In From the Cold, published in 1967, copyright expires more than 100 years later in 2090. Culturally important works like To Kill a Mockingbird are not free for public use for, again, more than 100 years after the creation. So it's unlikely that anything created now is going to be free to use during your lifetime. Trade secrets. I love the last line. Not great for mechanical devices. If someone can reverse engineer it, it's not very good subject matter for a trade secret. They last forever, but they're only as valuable as your ability to keep it secret. Now this is design patents, and here's of course the one of my favorites, assigned to Gibson. It's a guitar, and this is an ornamental design of a guitar. I mean, you can see the important parts of the guitar, the little tuning portions, the fretboard and the sensors to pick up the sound. Those aren't protected in their functionality, but this design is protected. And you can even do it for a web page. Here's Google's homepage, subject to a design patent. So they protect the ornamental characteristics. It really is not supposed to have utility unless it's a utility patent. That said, I've seen some design patents, for example, the Apple versus Samsung litigation. One of the design patents at issue, and that was multi-billion-dollar litigation, was a beveled edge. And I never understood why they didn't claim in that case that there was functionality, there was utility to the beveled edge because it required less materials. It allowed you to use different materials in the construction, but maybe they didn't feel like litigating that, or maybe they did, and I just didn't review the case closely enough. So finally, we get to utility patents, and here are the requirements. Okay, and there's a reason I have a mirror as the example in the example picture here. No prior art can teach every element required by the claim, and this is, there's so many sort of terms of art, and I think lawyers do it to prevent non-lawyers from getting away with not hiring us. But you use the broadest reasonable interpretation of the claim in reviewing it for issuance. So if your claim can reasonably be interpreted as exactly the same as something else that already exists, you're not novel and you don't issue. Not obvious. The difference between the invention and the prior art have to be such that a person having ordinary skill in the art, another, you need to hire a lawyer word, would not think to put the pieces together. Now this is interesting because the aggressiveness of the United States Patent Office in finding things able to be combined for obviousness purposes has increased dramatically over the last 100 years. So, 100 years ago, if you had a patent for a popsicle and a patent for ice cream on a stick, it might not have been considered obvious to do the ice cream on a stick just because you did a popsicle on a stick. But now it's very aggressive. You just need to get close to it, and you have obviousness. And sometimes you don't even need to be that close. It's almost become something that allows patent examiners to just reject your claims when they don't want to issue them. I mean, it's not quite there, but it's close. So staying on utility patents, we have the Supreme Court mystery box, which is the way I think about it, right? This seems pretty straightforward, right? Here's what's patentable. Any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. That's it. That's everything. There's no limitations other than it has to be new and useful, and it has to be a machine, a manufacturer, composition of matter, or a new and useful improvement on it. So it has to be new. So that's basically the requirement: new, useful, and that's not how it's worked. Patentable subject matter is a moving target. It will get its own episode, but rest assured that there's very little in terms of patentable subject matter that is clearly patentable, including such things as an improved vehicle axle. So this is probably why pursuing a patent on your own without a patent lawyer is not going to be as successful as you'd like. So let's go back here, back to the overlapping portion. So now, we have a sort of an understanding. Copyrights, these are, tangible expressions of an idea. So literally, this face is now copyright. That's just how it works. Trade secrets. Whatever's behind this that you can't see, that's my trade secret. Patents, and we know that there are design patents, and there's there's a category called plant patents, but then there are also utility patents, and and then there's trademarks off to the side. So hopefully you've come away with not too big of a headache, and we've gotten all the types of intellectual property out of the way. And I appreciate your listening. So next episode is going to be a little bit more fun, and a whole lot less on the legal work side. All right, don't forget to subscribe, and thank you for watching.